Okay, ladies and gentlemen, we're going to go ahead and get started with our program. Okay. On behalf of the W. Homer Drake Jr. Georgia Bankruptcy American Inn of Court, I'm Walter Kelly, and this year I'm the counselor to the inn, and Judge Jim Smith, the Chief Judge, Middle District of Georgia, is the president of the inn. I want to welcome each and every one of you to our meeting today. I couldn't decide whether to tell you this at the beginning or at the end, but I decided to go ahead and tell you that the bar tab is on the ends of court. So whatever you want to drink, it's on us. So I'll get that behind us. I also want to have special thanks to Elisa Watley for serving as liaison with the inns and facilitating our partnership with MACBAG. I want to thank Judge Diehl and Neil Gordon for our program, and thanks to all the judges and the attorneys, clerks, and pupils who are attending today. There are two purposes of the inn, and they are, well, there are more purposes, but these are the two I wanted to tell you about. To develop and promote professionalism in bankruptcy in Georgia through programs focused on ethics, practical skills, and civility, with an emphasis on mentorship and social and professional interaction. The second one I wanted to mention to you is to facilitate the development of law students, judicial clerks, recent law school graduates, and less experienced attorneys as skilled participants in the American court system. This year we have the most pupils that we have ever had, and it's 17, and they are. And many of them are with us today. Max Bowen, Kimberly Carbata, Stephanie Sangalia, Joseph Luna, Christian Morbidelli, Thomas McElhaney, Nicole Lawrence, Sydney Alexander, Kayla Barnes, Katie Phillips, Andrew Barth, Haley Patchen, Michael Berthume, Nicholas P. Greer, Jarrett Miller, Yogan Patel, and Brian Dayton. And we want to welcome them to the inn, and we hope that you will enjoy it as much as we all have. Each of the pupils is partnered with an experienced mentor, and actually, but in the bankruptcy world, and y'all, this is my 40th year of practicing law, and I still enjoy it. And there are a lot of people here that have practiced longer than I have, but I do enjoy it. I mean, we don't pick them, ladies and gentlemen. We just take them as we find them. But I really do mean this, that in the bankruptcy world, we are all mentors, and I hope that each of you will include these pupils and mentees in activities such as court appearances, 341A meetings, and social events. From those, they will gain very valuable experience. And as I said, the bar tab is on us, but we want to get started with our excellent program. Our two presenters need no introduction, Judge Diehl and Neil Gordon. Take it away, please.
Thanks, Walter. That was one of the longest introductions we've ever had. This is, I think, about the 20th presentation that Judge Diehl and I have made over the years, and we do a lot of them, 2 or 3 a year, almost every year.
It's always a mistake letting Neil go first.
She'll do the closing, and I'll do the rest. Let me get to, well, here's my favorite slide, but we'll go past that. No. The topic on suing universities to recover tuition paid for adult children is a relatively hot topic. I've been talking about it a few years, and sometimes it's a presentation unto itself. We've just mixed it in here, and this is a shorter version, but there are a lot of cases in 2018 alone that touch upon this. And the threshold issue is usually reasonably equivalent value. And the case I like to use now as a demonstration of how that might make you think about it in terms of paying an adult child's tuition if you're the debtor is this Wiersbicki case. It's a Wisconsin case and decided by the Seventh Circuit in 2016. And the holding was that intangible, non-economic benefits do not count as reasonably equivalent value in defense of a fraudulent transfer action. So what was happening in this case is that the debtor and Griswold had been long-standing business partners and friends, and As you can guess, they had a souring of the relationship, and then they ended up fighting it out in state court, and the lawsuit involved, for the most part, who was entitled to the family farm. And the debtor wins. The debtor gets the family farm, but Griswold files a series of appeals. And he loses them, of course, but he wears down the debtor so financially and emotionally that she just gives up. And so, while the debtor is insolvent, and solvency was not in dispute, it was undisputed that she was insolvent, the debtor transfers for $1 by quitclaim deed a 40-acre farm in Wisconsin with $151,000 of equity, and files a Chapter 7 case 14 months later. Trustee gets appointed. Trustee then sues to avoid the transfer. So the only issue in this dispute was reasonably equivalent value exchanged for the transfer. The purported consideration was stopping the transferee's endless litigation and appeals. And because, as we said, she was worn out by all that activity. So the bankruptcy court holds that stopping the meritless appeals had no value at all, and the circuit court agrees. The Seventh Circuit agrees and says that giving up the farm to eliminate the risk of losing the farm made little sense in terms of value. And moreover, that avoiding further family conflict was too nebulous in a bankruptcy context where the transfer put the debtor's property beyond the reach of creditors. Would creditors be willing to volunteer to provide a financial subsidy to enhance the insolvent debtor's family relationships? And you have to think about this in terms of paying an adult child's tuition. Would creditors be willing to volunteer to provide a financial subsidy to enhance the insolvent debtor's family relationships by allowing the debtor to put valuable property beyond their reach? So the transfer is avoided, the property goes to the trustee sells the property, pays a dividend to unsecured creditors. And there are a lot of other examples at the circuit court level, love and affection, and the burden on the marital relationship. These are all considered too nebulous, too vague, and undefined. So now we get to closer to the topic. How does this apply? All right, so all the standard Section 548 defenses are in play when there is a lawsuit to avoid the transfers to the university by the debtor on behalf of the adult child. All of them are in play. So you're going to have solvency, but the real fight tends to be over reasonably equivalent value. And that's why I start with that. And the courts are divided on whether there is reasonably equivalent value in paying an adult child's college tuition, although the majority view has been that it is not reasonably equivalent value. Because the problem that the debtor would have, or the transferee would have, is Section 548D2 defines value in a fraudulent transfer action, and it specifically says it does not include an unperformed promise to furnish support of to the debtor or to a relative of the debtor. And although that's not exactly what's happening, it's fairly close. Now, some of the more recent cases that have gotten into this, the Palladino case is Judge Hoffman's case from Boston, and he held that, we're not going to go into all of that case, and that's when it's a topic unto itself, but this was a Ponzi scheme debtor. So it's not like it was a good guy. But Judge Hoffman ruled that a financially self-sufficient daughter provided an economic benefit. I thought that was a bit of a stretch, but I can understand it. But this makes sense to me because he's in Boston. There's probably more universities in the Boston area than anywhere in the world. And so these universities don't want to be getting sued, of course. This decision was certified for direct appeal to the First Circuit Court of Appeals about 2 years ago. I've been waiting and waiting to update my presentation on this, but the opinion hasn't come out. Now, just a few months after it did the bankruptcy court ruling, Judge Coleman in Savannah, Ed Coleman, decided the Dunstan case, and he held that there was no economic benefit conferred, and he completely disagreed with Palladino. And he explains that any moral obligation to pay for college and help a daughter achieve financial independence did not provide an economic benefit to the debtor, did not satisfy any legal duty or obligation to pay, and it did not increase the debtor's assets in any way that could be used to pay her creditors. Another case, this is the Knight case, and there are a lot of cases out of Connecticut. I'm not exactly sure why, but the Knight case, Judge Tancredi also agreed with Judge Coleman that it conferred no value to the debtor within the meaning of Section 548, and the expectation of future economic benefits was too speculative. In his discussion of the case, he said the only issue was whether reasonably equivalent value was received in exchange for paying the adult son's tuition. The debtor had argued that enabling the son to move out of the house and to achieve financial independence was sufficient value. And from everything I read, that the millennials today, when they graduate, these boys move right back into the basement. So I'm not sure that actually works. But the university was arguing that the value received was the discharge of the familiar obligation to pay tuition and expenses. And the court said that while it was admirable to pay for the education, there was no legal obligation to do so, and the transfers did not satisfy a present or antecedent debt of the debtor and did not confer value to the debtor within the meaning of Section 548. Now, in addition to the standard defenses, there are some unique defenses to attempted clawbacks of tuition payments that you're not likely to see in any other 548 action. How many of you are familiar with Section 529 plans? Not many. At Gary Marsh's request, I taught his advanced bankruptcy law class at Emory last month, and I asked the students how many of them were familiar. None of them were familiar. I thought this was a more common knowledge than that, but apparently not. And so these 529 plans allow, it's a set-aside fund that you can reserve for a child or a grandchild for their college expenses. And if you look at Section 541B6, the reason I keep turning back is I can't see what's on the laptop screen very well. But Section 541B6, property of the estate can exclude funds contributed to one of these plans. And there's limitations on what you can contribute and how far in advance of the petition date, but some transfers from such an account would be protected and would not be clawed back. But you must be able to adequately trace the funds to the debtor's 529 plan. So if you're arguing a defense of a 529 plan, then you're going to have the burden of tracing it back and showing that it actually came out of the 529 plan. Because some of the cases show a certain amount of commingling and making it more challenging. It's just not that clean. And you may need evidence of the debtor's other income and expenses during the relevant time periods. Now, moving on, how many of you have heard of the Federal Direct Parent Plus loans? I see a couple of hands. Must be the mentees that know about this. So this is governed by the Higher Education Act of 1965, which I had never heard of until I started doing research on this. The parent can borrow to pay for the tuition and other qualified educational expenses. The parents never receive the money. And this is important. The money never goes to the parents. It goes directly from the lender to the school. Now, what that does is, what you see up there are two cases, again, both from Connecticut. And both of them, and we'll go through this and you'll see why this matters, both of them had this Federal Direct Parent Plus loans. The university received the transfers via that, and I'm going to use the Demetris case as the example. It's only time for one of these. And for the adult child's tuition, this trustee sued to recover about $67,000. The university moved to dismiss, and that motion was granted. And this is important because Judge Tancredi is the one in the Knight case who said it wasn't reasonably equivalent value, so it's not like he's got this particular bias in one direction or another. He doesn't. He says that, no, the transferred funds did not constitute an interest of the debtor in property, that the funds could never have been considered the debtor's property. They were never within the reach of creditors. There was no diminishment of the debtor's bankruptcy estate, and the funds had been earmarked from the lender directly to the university. And I think that's right. But my comments, when I'm talking to the trustee groups, I say the way I think you attack this is different. That what the trustee should have done is sued to avoid the obligation itself. We don't see it that often, but in 548, it's also the incurrence of the obligation that can be fraudulent. So it's the same reasonably equivalent value test. So seek to avoid the obligation itself is fraudulently incurred because the debtor likely did not receive reasonably equivalent value for incurring the obligation. Then sue to recover the loan repayments made by the debtor to the lender within the applicable reachback period as fraudulent transfers. Still would not be a claim against the university, but you might get a recovery against the lender. And still more recent cases in a different direction. This is from Judge Carla Craig in New York. This is I don't know if it's pronounced, I call it Adamo, but I'm not sure. And she's looking at this in the context of a commercial conduit, which is a more familiar term to the Chapter 11 lawyers who are in the room, maybe than the consumer lawyers. But in this instance, the trustee had sued 3 schools, Hofstra University, Fairfield University, and Brooklyn Law School, for about $278,000, so it's a significant amount. All 3 schools had treated the funds similarly. And this was also new to me. I hadn't seen this way of treating it. But the school accounts were created by each student with a unique username and password. The funds are then placed in the account through an electronic portal. After the debtor transfers the funds to those accounts, the debtor could not access the accounts absent an account holder's authorization, nor could the schools utilize the funds. If the student withdrew from the program, the student received the refund of the account balance, not the parents. Any payments credited to the account were considered credits belonging to the student and not to a third party, including the parents. So the court rules that the schools did not exercise dominion and control over the tuition payments and were mere commercial conduits. The court equates these student portals to a bank account with the students as the initial transferees and the school as the subsequent transferees. So then the schools pick up the protection as a good faith transferee under Section 550B, and that's going to be a fairly easy one for them to establish, I would think. The Chapter 11 lawyers are going to be familiar with the bonded financial services case, and that's actually a case that the judge relies on here. And the conclusion is that the school's electronic system was merely holding the funds for the student account holders, and that the schools, the transferees, were mere conduits. So, unless there's questions, we're going to move on to...
I mean, I think, Neil, and we've said this before, that all the university counsel or people that represent universities get together just like bankruptcy lawyers do, and I'm sure that there is discussion of how to structure the receipt of tuition from a parent so as to protect yourself against a subsequent bankruptcy trustee coming after it, which is why I think you'll see the more recent cases are in this commercial conduit reign.
I think the Carla Craig one, it was kind of a roadmap of one of the ways to do it, and I think that's going to become the predominant. I should have mentioned that if you're suing a state university, you're going to be dealing with the Attorney General's office quite often. You're not going to be dealing with a private law firm. But even when the claims are fairly small, you see giant law firms defending these universities. It's not like you would expect. You sue for $20,000 and an 800 lawyer firm is the one who files the answer or contacts you. It's a little unusual. But I spoke less than a year ago to the National Association of Attorney Generals, and Judge Coleman was there with me, and Jack Williamson on that panel. But when I got to this topic, boy, they were really emotional. Their spirits were up. And so that told me that they were from all over the country, that they were getting a lot of these lawsuits, and that they didn't care for them. The next topic, which Judge Diehl is going to take. Somebody. Yes. Well, if you're satisfying a debt, that's what if I understood your question, if you're satisfying a debt, that's usually sufficient. You might have a preference, I suppose, but if it was in a certain time period. But if you're satisfying a debt, I think that is.
I have not seen any cases that deal with that factual scenario, but I think Neil is right. It's likely that that's totally different than doing it voluntarily.
Well, that's a great question, and another question I often get is, what about minor children that are in private school? And I've always told trustees, leave that alone. That is, you're not going to win. But sometimes the U.S. trustee goes after those under 707 and tries to get a case dismissed. I know of that happening in our district where it was successful, but so that goes in a different direction. What's happening with the next topic is I started seeing a lot of cases that were clustering on whether these, there's an awful lot.
Let me do it. Okay. It's my topic.
Well, I was going to
Okay.
talk about the overview of 3 topics, and then I was going to give it to you.
Well, this is it obviously deals with property of the estate, but I'm going to talk about 5 cases that all have very similar factual scenarios, and the question is really when there's an undisclosed cause of action, when is that property of the estate? And so each of these cases, basic facts are the debtor has some kind of a medical procedure prior to filing a Chapter 7 case. After the case is closed, the debtor gets his or her discharge. The debtor then becomes involved in product liability litigation related to that surgery and becomes entitled to a settlement payment of some sorts. So in each case, the trustee or the U.S. trustee, depending on the practice in the district, I think here it's the U.S. trustee that would move to reopen the case to administer the asset, i.e. the undisclosed litigation, as property of the estate. I've got 5 cases. In 2 of them, the court agrees with the trustee. In the other 3, the court sides with the debtor. So let's start with the 3 cases that deal with the debtor. The first one is Mendelsohn, which is out of the Eastern District of New York. And the timeline there is 1999. The debtor has a mesh sling implanted. 5 years later, in 2004, Chapter 7 is filed, the discharge is granted, the case is closed in 2006. So we're already 7 years after the procedure. July of 2011, so 5 years after the case is closed, the FDA issues an advisory about possible defects with the mesh sling. In 2012, the debtor hears about it, contacts a lawyer, and subsequently gets an award of $105,000. The bankruptcy court, and this is Judge Grossman, held that no cause of action had accrued as of the petition date, and thus the proceeds were not property of the estate and not subject to administration. On appeal, the district court affirmed, and they say whether a cause of action was possessed by the debtor and therefore was property of the estate depends on whether the claim had accrued as of the date of filing. Here, there was no injury. The debtor was settling only a potential claim, and it's a legal question when it accrues, and the court has to determine whether the claim is rooted in the pre-petition past. Accrual is not really relevant in terms of settlement of a potential claim, and so here the implant was pre-bankruptcy, but without the post-petition events, i.e. the FDA warning, there'd be no basis for her to settle anything. So her claim was created by the discovery of the defect in a product. That occurred post-petition, and the bankruptcy court was then affirmed.
16-year timeline there.
Right. So then the next case is In re Bolton, which is Judge Pappas in Idaho in January of this year. There we have October of 2007, the debtor has hip replacement surgery. He saw the doctor several times over the next year, had some pain, but the doctor's notes always indicated that he was doing well. July of 2009, he files bankruptcy, gets a discharge, case closed in 2011. Several more doctor's visits during the bankruptcy, and he had another hip surgery, a revision surgery. Then in March of 2012, he gets an attorney. They file a product liability action against the manufacturer used in the hip replacement. In 2017, the trustee gets advised that the debtor had been offered $235,000 to settle his claims. So the trustee moves to reopen the case. That's granted. The debtor amends his schedule to include the claim, and then he amends Schedule C to exempt the proceeds under Idaho law, and the trustee objects. So the court says to determine if the claim is property of the estate, the court has to look to Idaho law, which requires a plaintiff to allege and prove injury that was a result of the defective product and that the defect existed when the product left the control of the manufacturer. Thus, until the debtor was injured, he had no cause of action. And here the court says, well, there was no injury occurred pre-petition, so the cause of action is not property of the estate. The trustee argued that it's property of the estate because it's sufficiently rooted in the pre-bankruptcy past. The court rejects the argument, saying that the pre-petition action, the implanting of the defective component, was of no use to the debtor because there was no injury until after the case was filed. In other words, the elements of the cause of action were not present at the time of the filing of the bankruptcy, so it's not property of the estate. Debtor gets to keep the money. The final case that goes that way is Colleen Brown's out of Vermont in February of this year. And there we have an October 2005, an implanting of a defective device, a vaginal tape to treat stress incontinence. And the problem continues even after the surgery. In June of 2009, she seeks further advice, and in June of 2010, so 5 years later, she files Chapter 7. It gets discharged a mere 5 months later. They're really quick in Vermont. March of 2011, the debtor seeks further medical treatment. And then in 2013, so we're now 3 years after the bankruptcy's closed, she sees an ad on TV and believes she might have a claim. She contacts an attorney. Suit gets filed in 2014 and becomes part of multi-district litigation. In 2017, she's offered $45,000 for the release of her claim. The trustee learns of the claim, files a motion to reopen the case. The court, in evaluating whether to reopen the case, discusses what makes a claim property of the estate. And the general rule is that a claim which accrues post-petition is not property of the estate unless it's sufficiently rooted in the pre-petition past. So the court has to look again to state law, here Vermont. And Judge Brown says under Vermont law, a claim does not accrue until the plaintiff knows or should have known of the injury and its likely cause. The trustee argued that accrual for statute of limitations purposes is different than ownership of the cause of action. Judge Brown rejects the trustee's argument, and she says, I got to rely on Vermont law, and there's no evidence presented that the debtor knew or should have known of the injury, and so she denies the motion to reopen, in essence, because it's not property of the estate. So those are kind of the three cases leading up to the earlier part of this year. Then we have the next two cases. Then the first one I'm going to talk about is out of our district, where the trustee wins. In Ray Davis is Judge Sacca's case in May of this year, and there we have a July 2010 insertion of a vaginal mesh sling. October of 2010, the bankruptcy's filed, discharge closed in February of 2011. We're also very quick. In July of 2011, the debtor sees this ad about the FDA warning, has the sling removed, and consults an attorney. So the case is reopened on a motion by the U.S. trustee when he learned that she was entitled to settlement proceeds. Judge Sacca says, well, Georgia, like Vermont, has a discovery of harm rule for accrual of a cause of action. But the test for property of the estate is whether all the elements of the claim have occurred as of the commencement of the case. Under Georgia law, the cause of action exists as of the instant the injuries were inflicted. When they were discovered is only relevant for purposes of the statute of limitations. So he says, yes, it is property of the estate, and the trustee wins. And I think if you take that analysis, both Bolton and Vasquez, the Idaho and the Vermont cases would have been decided differently. The final case goes the same way as Judge Sacca. It's in Ray Carroll. It's Judge Sargis out of the Eastern District of California. And I think this case actually has the best discussion of the differences between ownership of a cause of action and the accrual of the cause of action for statute of limitation purposes. So if you want to read up on this, read this one case. The site is in the slides. But this is 2003. There's the implant. The debtor has 3 more surgeries in the next couple of years related to problems with the implant. In 2009, the debtor files Chapter 7. The case gets discharged. It's closed. In 2014, the debtor learns of the FDA warning, joins the class action, becomes entitled to $200,000. So we're now 11 years after the surgery. The debtor, being upfront, files a motion for the court to determine that her settlement payment is not property of the estate because she didn't know about the claim until after bankruptcy, and therefore her claim did not accrue until she had knowledge. Trustee opposes the motion, argues that the debtor knew or should have known based upon her pre-bankruptcy surgeries, and she had admitted that she had consulted an attorney back in 2005. The court then goes to great length to explain when a cause of action accrues for purposes of determining the statute of limitations is different from determining when the rights become into existence. 541, property of the estate, doesn't distinguish based on the debtor's knowledge of the property or the claims. A legal interest is one in which all the elements of the claim are present at the commencement of the case. Lack of knowledge doesn't matter. The court goes on to talk about the Ross and Mendelsohn cases, the first case, the Eastern District of New York, and notes that in that case, there was an agreement between the trustee and the debtor that there was no pre-petition injury upon which a claim could be based. Since the injury was a necessary element, this case is different than the case before Judge Sargis, where the injury was pre-petition. So the trustee wins. I think if you're a trustee, certainly, and also if you're debtor's counsel, you need to read carefully this opinion, because you also have to think about whether or not the cause of action is based on actual injury or whether it's a settlement of a potential claim, and that could make a difference as to whether or not it becomes property of the estate.
You know, we deal, as trustees, we see a lot of these, and I would think the Consumer Debtor Bar, sometimes it's the debtor who's moving to reopen the case. Sometimes it's the U.S. trustee, and in some places it's the trustee, although technically trustee was discharged and may not have standing. And so I think the best practice is we report it to the U.S. trustee and let the U.S. trustee file the motion if they deem it appropriate. But in other places, it's done differently. A lot of these recoveries don't require any injury in these class actions. You're categorized based on certain factors, and I don't know, they have an algorithm, I think, that decides who's going to get what, but you might get $45,000, $50,000 without even having an actual injury just because a device maybe, or if you remember the FinFin litigation, which was a weight loss just by having taken it, and if you were having problems, even if they are completely unrelated to the product, you still fall into certain categories. And these cases aren't talking about things like that, so we don't really have that kind of But we have, these cases keep coming, and I think they're pretty much just cumulative of what we just covered. And when I was reading these, I read them separately, and then I started reading cases over the years about the exemptions, and then I realized these all fit together, and so does judicial estoppel. And so I put them together into a combined topic. So what happens if you clear the property of the estate hurdle? You're in Georgia, you've got Judge Sacca's opinion, you go ahead to administer it if you're the trustee, but then the debtor comes in and claims certain exemptions. Can the debtor exempt this? The dicta in Law v. Siegel, as we all know from the Supreme Court in 2014, said that the debtor was entitled to an exemption even if claimed in bad faith. And most courts have been following the dicta, even when they recognize it's dicta, because it's the Supreme Court. But does that apply in a reopened case? That's the question here, because these cases we're talking about are all reopened. And here we have 4 recent decisions on this topic, and they discuss it in great detail. The first case that's on the screen, the Awan case from Judge Gorman in Illinois, is a great discussion, great overview, and I would recommend this one if you really want to get a feel for the area. So we all hear you can freely amend your schedules, you can freely amend your schedules. We hear it all the time, and we believe that to be the case. But its genesis is this rule that's on the screen, 1009A, that the schedule may be amended at any time before the case is closed. But that's the issue here. The case has been closed. So what happens when it's reopened? Now, in this particular case, the debtor was not permitted to amend the exemptions in the reopened case. So the U.S. trustee, as we said, had moved to reopen the case to have administered by the trustee a previously undisclosed claim The case gets reopened, the trustee gets appointed. The trustee then seeks to adopt the pending settlement that's already been negotiated, apparently, and to pay creditors in full and have a surplus. That sounds pretty good. After all this is done, the debtor then comes in and amends the schedules to disclose and exempt the recovery in full. The trustee objects, asserting that the right to amend in a reopened case is not automatic. It is subject to an excusable neglect standard under 9006B1. And I've been advocating this approach for years on the listserv, but it's only now getting followed because of all of these cases that have been coming up. These reopenings have just been a flood of them nationally. Court sustains the objection, and this is what's important, and this is where you see the different outcomes. 3 different categories of outcomes in these reopened cases. The first approach is that Rule 1009A prohibits amendments even in reopened cases. So in that case, you're not going to be able to amend if you follow that. The next one is just the opposite, and it doesn't matter. You can still freely amend. And then the middle one is there has to be a showing of excusable neglect under 9006B1, which is what the court here adopted. And the court had given the debtor an opportunity to show excusable neglect, but for whatever reason, the debtor declined to do so. The court says that Law v. Siegel was not implicated because this objection was not predicated on any bad faith conduct. It was predicated on noncompliance with the bankruptcy rules. But one of the important points in this is a trustee would normally, as the objecting party, have the burden of proof on exemptions. That's sort of ingrained. But when you're talking about is there excusable neglect, the debtor has the burden of proof on that issue, on excusable neglect, and that's what the cases all find. And the next case, which came out of New Mexico, the court holds in this Dahlman case that the debtor is not permitted to amend exemptions in reopened cases. In this case, the debtor was, I'm kind of amused, the debtor was injured in a Walmart parking lot when a bag of firewood fell on her head, but it says allegedly injured, Sounded pretty good to me, but allegedly injured. The petition date was 9 months later. The claim's not scheduled. There's no exemption claim, even though the debtor asserts that she had informed her bankruptcy counsel about the claim. It's not disclosed at the 341 meeting. Trustees ask about claims and lawsuits, but it's not disclosed. Only after Walmart, who was the defendant in this action, asserts judicial estoppel, which Judge Diehl is going to talk about shortly, does the debtor reopen the case, and this is now 3 years after the petition date, and claims the exemption, and that's when the trustee objects. So the court holds that the burden of proof is on the debtor to show excusable neglect under Rule 9006B. And the court follows the test set forth by the Supreme Court in the Pioneer Investment case, which, of course, was a bankruptcy case. I think it was a late claim case, but it says the failure to act must be the result of neglect, and the neglectful act had to be excusable. Here, the court found neglect was established, but it was not excusable. Under Pioneer standard, the clients were held accountable for the acts and omissions of their counsel. Here, the debtor and counsel both knew pre-petition of the PI claim, but waited more than 3 years and only did so after the Walmart asserted judicial estoppel motion in the state court action. In the next case, the Benjamin case out of New Jersey, this is actually a reconsideration. Where on reconsideration, the debtor was not permitted to exempt the concealed asset in the reopened case. The PI lawsuit had been filed over a year before the petition date, but it's not scheduled. Trustee doesn't know about it. It's not disclosed at the meeting of creditors. Trustee files a report of no distribution. Case gets closed. That doesn't take very long either. Over 2 years later, the debtor executes a settlement agreement that would produce a net recovery to the debtor of almost $20,000. A third party contacts the trustee and tells the trustee about the settlement. So the case gets reopened. 4 months later, the schedules are amended and the recovery is claimed as fully exempt. The debtor does the trustee negotiates a new settlement for almost $38,000, so almost double what the previous settlement had been. And that was going to be the net to the estate, and the debtor amends to claim $35,700 of it as exempt, almost the entire amount. The court first ruled that against the trustee, but then granted the motion to reconsider and struck the exemption. The debtor was then given the option of seeking leave to amend to try and establish excusable neglect. But the court notes, and that's in quotes, this may be difficult to establish on this record. Often the party with the burden of proof loses, and when the burden of proof is on the debtor, it makes it difficult on most of these facts. I'm going to skip, because time is running, I'm going to skip this next case, where by the time the motion to reopen was filed, the debtor was 96 years old. And I would have applied the excusable neglect standard, but... And I wanted to talk instead about this case that came out of the Ninth Circuit Court of Appeals on exemptions, which is really not directly related, but it's a very interesting exemption case. So the question was, can the filing of an adversary proceeding also serve as an objection to exemptions? And what had happened on the eve of the Chapter 7 filing, the debtor had transferred 2 commercial properties to himself and his wife as tenancy by the entirety for no consideration. Georgia is not one of the 17 states in the country that's a tenancy by the entirety state. But if you have debtors who have moved from other states and, you know, they're your client now, you might have to deal with this. Or trustees might have to, depending on how long they've been in the state of Georgia before they file and what state's law is applicable. But a trustee fails to file an objection, never does file an objection to exemptions, but had filed an adversary proceeding within 30 days of the conclusion of the meeting of creditors, which is the deadline set in Rule 4003B. And the adversary proceeding sought to avoid the transfer and requested turnover. Trustee wins the adversary proceeding. Debtor then says, good for you, but it doesn't mean anything because you never objected to exemptions. Bankruptcy court, all the way to the Ninth Circuit, disagree with the debtor. The form of the objection is not specified in the rule. The adversary proceeding was sufficient. What was strange about this case to me is the Ninth Circuit doesn't mention Section 522G1 or its own precedent, Glass v. Hitt, which was from 1995, which held it was not necessary for the trustee to object during the 30-day period as to property recovered under the trustee's avoidance powers. Otherwise, it would turn a 2-year statute of limitations into a 30-day statute of limitations, and the very creditors injured by the transfer would be further injured. And furthermore, a trustee had no basis to object until the asset was recovered for the estate through avoidance of the transfer. And the reason I mention this is this holding was adopted by the 11th Circuit in the Levine case in 1998. This is our law, too. But it was just odd that it wasn't, their own precedent wasn't even mentioned. Now, the third prong, which Judge Diehl is going to take from here, is how judicial estoppel fits into all of this.
Okay, and I'm going to talk just briefly, because you've probably heard this at other of our seminars. Start with Slater versus U.S. Steel, which is the 11th Circuit precedent on judicial estoppel. And the facts in it are very typical of cases involving judicial estoppel. So the debtor here has a suit pending in district court against her employer, U.S. Steel, for race and sex discrimination. And while that district court case is pending, she files a Chapter 7 case with a different attorney, of course, than the one litigating in the district court. Debtor doesn't list the pending lawsuit in her schedules or disclose it on her statement of financial affairs, and the trustee issues a report of no distribution. U.S. Steel then turns around and moves for summary judgment in the district court on the grounds of judicial estoppel. The debtor testified in the district court that her omission was not intentional, and she had misunderstood the question. She thought all she was supposed to disclose was lawsuits against her, not lawsuits she had. So then she goes back and amends her schedule and her statement, and the bankruptcy trustee comes in, employs counsel to pursue the claims. She then converts her case to a Chapter 13 case, and eventually it gets dismissed because she doesn't make her plan payments. In the district court, U.S. Steel's motion was granted. The district court says the test in the circuit is the judicial estoppel applies unless the omission is inadvertent, and that means that the debtor lacked knowledge of the claim or had no incentive to conceal the claim. This was the test that the 11th Circuit had applied in the Barger versus City of Cartersville case, and the district court found that she knew about the claim, she was pursuing it, and she had a motive to conceal it so she could retain the settlement proceeds. So judicial estoppel barred her claims. The 11th Circuit affirmed, but there was a very strong concurrence by Judge Joe Flatt, who said we're bound by prior precedent, but there's many problems with the precedent, including the fact that it operated to the disadvantage of the debtor's creditors and gave a windfall to the litigation defendant who had nothing to do with the bankruptcy. So the matter was reheard en banc. Judge Jill Pryor, writing for the circuit, says the test used by the district court was wrong, and the determination of whether an omission is inadvertent depends upon an application of the totality of the circumstances test. So if there is an inconsistent position taken by a debtor, the court has to look at the sophistication of the debtor. These are examples of the facts. Whether and under what circumstances the plaintiff corrected the admission, whether the debtor had advised bankruptcy counsel or the trustee about the civil suit, whether there were other suits the debtor had that were disclosed. So the case was then remanded to the district court to make further findings. The only 11th Circuit case we have since that time that theoretically applies the Weekly versus Eagle Logistics is a per curiam in June of this year, and there we have a pro se plaintiff who filed 2 lawsuits in Alabama State Court for breach of contract, and the debtor files a Chapter 13 case, which was his 5th bankruptcy filing, also pro se, amends his schedule 6 times during the Chapter 13, but still doesn't disclose these 2 lawsuits. So the defendants in the civil action moved to dismiss based on judicial estoppel, and the district court granted the motion pre-Slater en banc, so they're not necessarily applying the totality test. The 11th Circuit reviews for an abuse of discretion, applies the totality of circumstances test, and affirms, noting that the district court relied on the factors, the type of factors that they had talked about in Slater. There was a disclosure of other lower value lawsuits, the fact that the amendments, he'd done 5 or 6 other amendments, and the fact that all these prior cases meant he should have known what was required in the filing. The debtor also argued that his voluntary dismissal of the Chapter 13 case made the judicial estoppel argument moot. The 11th Circuit disagreed, and it said we have to protect the integrity of the judicial system, and so we've got to apply the principle in that case. Okay.
I didn't tell Mary Grace about the other case because I just read it last night, and there's no time to put it into this. It's called Silva, S-I-L-V-A, and it really doesn't add anything to the discussion because the district court there was applying the pre-Slater law because it was while it was on a further appeal that Slater got decided. And so unlike Weekly, where the district court did the totality of circumstances analysis anyhow, this district court didn't, or the magistrate to be more exact, and so it got reversed and remanded. But that is out there also.
And we've got in the materials a Second Circuit judicial estoppel case, and this is one of those where once you read the facts, you know how it comes out. It's a Chapter 13 debtor with a 100% plan with interest to all the unsecured creditors. In month 60 of the plan, the husband is diagnosed with mesothelioma, and he decides to sue 60 defendants about who possibly could have caused it. They complete the plan, the 100% plan with interest. He tells his bankruptcy attorney, who says we don't need to do anything, and one of the defendants moves for summary judgment on the basis of judicial estoppel, and the district court grants the motion. Oof. They appeal, and then the debtor dies while the appeal is pending. The appeal is continued on behalf of his state, and guess what the Second Circuit does? Of course, they reverse and remand. They said judicial estoppel is really an equitable doctrine, and under these facts, to deprive the debtor wife of the claims would be to turn the concept of equity on its head. They did decide, however, that all they had to do was review it for an abuse of discretion standard, and even under that standard, the district court had abused its discretion. So then you've got a couple of cases up there that talk about what if it's not the Chapter 7 debtor, but it's also the trustee? Are they estopped? And we've got a couple of cases on there that say, no, it doesn't apply to the trustee, which of course makes sense because the trustee hasn't taken any inconsistent positions.
And why should the unsecured creditors who've done nothing be penalized? But believe it or not, after the 11th Circuit decided the Parker v. Wendy's case, which is up on the screen in '04, the Fifth Circuit panel, I remember Edith Jones' panel opinion, went the other way. Right, they reversed it. They reversed it, and the debtor, how it works is that, and this is interesting, so the trustee still brings the claim, but the debtor recovers nothing, no exemption, no surplus. So the defendant only has to pay enough to take care of the bankruptcy estate. And once the bankruptcy estate is taken care of, they have successfully limited their exposure and their liability. Okay, but then the
defendant also has to take care of the plaintiff's attorney's contingent fee under the recast.
right. That's the yeah.
Paying to the trustee, and then the trustee pays all the claims, and then refunds the surplus.
Right, that's what's on the screen now. As a matter of fact, these cases on the point that Judge Bonifeld was just mentioning. So the question was, if the debtor is barred by judicial estoppel, and is the trustee who can still bring it limited to pursuing only the amount of the allowed claims in the case? And the answer is no. The Metru case from the 7th Circuit in 2015 and the Flugents case from the 5th Circuit, I can't even read it, from the 5th Circuit in 2013 said no. And the explanation that they gave was that, so let's say that you have a $20 million claim. You can get the best lawyers in the world to handle that for you. But if the defendant is limited to just paying $20,000 or $50,000, you're not going to get the best lawyers in the world to handle it. And so that was the explanation. So the special counsel, what Judge Bonifeld is referring to, special counsel have to be paid in full as well, and not just for the limited amount that is owed to the estate, but for their percentage of the full recovery. And so they will get paid. You'll get the best lawyers, and they will get paid in full their contingency. Did I get that right, Judge? Yep. Okay. So any more questions?
That's it.
If not, we're done.